now sitting at Boston, Rubin, and for the Commonwealth. You are there, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Englander. To my left, Justice D'Angelo. We will be hearing a single case this morning. It is number 23-295, Commonwealth versus LOPEZ-ORTIZ. The rules are straightforward. It's 15 minutes per side with no rebuttal. I don't seem to have, if either side is splitting its time, which I don't think they are, no. You would have to tell us, but now you don't have to tell us. With that, we will hear first from attorney, and again, I don't have the list here. I don't know if it's Shea or Nathanson, but you'll let me know.
Good morning. May it please the court, David Nathanson for Roberto Lopez-Ortiz. With me is trial counsel Mark Shea, and Mr. Lopez-Ortiz's family is in New Hampshire watching the live stream. I'd like to actually start with the peremptory challenge issue and then turn to the felony murder issues. So the prosecutor struck a Puerto Rican juror, and it was over objection, and it was both not a race-neutral rationale, and it was a pretextual set of rationales. The main problem in the race-neutral inquiry is that the prosecutor's rationale, combined with, in fact, how the judge analyzed it, is that it assumed that the juror's race would cause him to be biased. And there was this focus on the juror's comment about the veneer's unrepresentativeness and the juror's disapproval of a voir dire question about the criminality of Puerto Ricans. And then combine that, is followed immediately by the judge's comment, incorrectly, but explicitly referencing the juror's race, which is that the juror had strong feelings about people of his race being mistreated. And so those rationales, drawing this community based on race between the juror and Mr. Lopez-Ortiz is not race neutral. And I would commend to the court Porter versus Coyne-Fague from the First Circuit, which is instructive on the issue. It's a similar set of issues where the juror didn't say.
In Porter, did the First Circuit reject a finding of the trial judge with respect to the genuineness of the reasons given?
The genuineness.
Because isn't that what you're asking us to do? The judge found that the reasons were genuine and adequate. That was a statement that she made. So you're asking us to reach the conclusions that you just stated.
Yes.
In the face of the record and in the face of those findings. Essentially to do what? Say it was clear error?
Yes, Your Honor, and to the extent that there's a discretion involved, it's an abuse of discretion. And I'll just get right to that. Step 3. There are 4 factors that I'm asking the court to focus on. First, the initial reaction. Second, misstating the record. 3, the reliance.
What initial reaction? I'm sorry.
I'm sorry, the prosecutor's initial reaction, which is the prosecutor saying, may I have a moment, and then the later protestations of it has nothing to do with race. And I'm not just making that up. That's in SJC case law, Maldonado.
But to me, that's a catch-22.
Sure, yes, it is. Yes.
This is a peremptory challenge. It's
Yes.
a peremptory challenge. And we've reached the point where no matter what the prosecutor says, it's evidence that the prosecutor was making a decision based on race.
Well, so that's
If
only.
they say it's not based on race, it's evidence that it was based on race.
Certainly, Your Honor. That's why that factor can't be determinative. It's only a clue. But it is in Maldonado, and it is in Miller L. from the Supreme Court. But the prosecutor misstating the record. So the prosecutor said that the juror believed that Mr. Lopez-Ortiz couldn't get a fair trial. The juror never said that. And the judge misstated the record too, saying that the juror had strong feelings about people of his ethnicity being mistreated.
Is it an unfair characterization? So your argument is that it's an unfair characterization of what the juror did say, which is, I don't see any Spanish people out there, and I'm paraphrasing, but I'm trying to get it close. And I think, given what's at stake, he should have some of, is the words he used, his people, quote unquote? Okay.
Right.
So you think it's an unfair characterization of what the juror said, that he didn't think, and who said, the words that you just used were that he could not get a fair trial. Is that actually what was said? Was that said by the prosecutor or by the judge?
It was the prosecutor, and his beliefs that he feels that the defendant cannot get a fair trial. That's appendix page 47. So there's that. So the juror never said those things, and Mr. Shea did say that's an unfair characterization. He's simply stating that
You say it's on page 47, or is that appendix page?
Appendix page 47, trial volume 2, page, I think, 44.
Empanelment volume 2 is how we've,
Yeah. Volume 2, page 44, or appendix page 47.
Beliefs that he feels the defendant cannot get a fair trial. Okay.
And so the juror is entitled to make an observation. That doesn't mean that the juror is biased. In fact,
But the prosecutor's not saying he's biased. The judge made a finding that he wasn't biased. That's why there was no challenge for cause. What the prosecutor is saying is, I want to exercise my peremptory because even though, Judge, you're finding that he can be fair, I don't think he can be fair and impartial. What's wrong with that?
well, first of all, the prosecutor never asked the juror whether he thought Mr. Lopez-Ortiz could get a fair trial. She simply asked if he, the juror, could be fair, but she never inquired about the thing that she pointed to as her peremptory reason, and that's additional evidence of a pretextual strike. The DA never asked about his interaction with police when she had the chance to follow up, and trial counsel objected on these grounds. Perhaps the most troubling part of this is the demeanor-based strike, and this is an invitation to pretextual discrimination.
But again, counsel, I understand why you're arguing this, and I understand there are cases that talk about it, but that is exactly why we defer to findings of trial judges, because you can read body language. You're allowed to read body language. That's why we have jurors, is to read body language, right?
Yes.
So I don't, again, it feels like catch-22 to me. It's like, well, if you mention that actually you're reaching a conclusion based on the way that the juror answered questions, how long they took, whether they hesitated, that is evidence that it's race-based, which is what you're arguing, right?
Yes, yes.
Okay.
And so the evidence, first of all, Justice Marshall warned us that demeanor is an invitation to discrimination. The evidence from the California studies and some other studies have shown that it is evidence of discrimination. But to Your Honor's point specifically, that's why the standard is from Maldonado and Snyder from the Supreme Court, that if you're going to have a demeanor-based strike, there has to be findings from the trial judge that validate the demeanor-based strike. And here the judge explicitly declined.
I don't recall the court saying it that way in Maldonado.
So Maldonado says, you're right, they did not explicitly require it. What they said is we really need them, because otherwise it really is troubling that this is a race-based strike. Snyder says that we're not going to defer to any findings unless you make them. And so
Trial counsel object to the prosecutor's characterization of the demeanor of the juror?
So no, he didn't have to, because the judge explicitly declined to endorse the prosecutor's characterization. So what was there for him to do? He didn't have to do anything, okay? And then there's the differential treatment of the juror. There were 6 other jurors with criminal charges. She didn't ask any questions of those jurors, and she struck only one. And then in terms of the framework, the judge ended this colloquy by reverting to, after rebuffing Mr. Shea's objections, reverting to there's no pattern. And that suggests that the judge may have been operating with an improper framework, an improper analysis, because we know that pattern.
Case tried, 2017?
Yes.
Isn't that the correct statement of the law at the time? She says one single one is enough. Right after she mentions pattern, she says one is enough.
Yeah,
I think it was a correct statement of the law at the time.
So Jones and Ortega are from that time. I'd have to check. But it was, if you look at Sanchez, the Dagoberto Sanchez from the SJC, they try to clarify that.
Sanchez is the one that moves away from pattern, written by Justice Lowy?
Yes.
That postdates 2017, I'm pretty sure.
But what I was trying to say is that Sanchez says it was always the law that pattern is not really favored. It's not the best way to do this. And so what I'm saying is when the judge is analyzing it, I'm suggesting that she's using an improper or incomplete framework because she's refusing to engage with all the factors because she's focusing on a factor that's disfavored. So turning to the felony murder issue. There are 3 felony murder issues, but I want to start with the retroactivity issue. So Mr. Shea objected to felony murder, and for 40 years it's been the law in Massachusetts that if you object correctly, you argue for a change in the law, you get the benefit on direct appeal, regardless of whether it's constitutional or common law. There are examples of that. Matchett, which is second-degree felony murder. Wolf, OUI, Hernandez, which is the Commonwealth, getting their objection on direct
How do
appeal.
you square this case with Shepard, which came out in February?
Right. So Shepard was not preserved. I looked at it. I looked at the colloquy. Defense counsel makes a reference
I'm
to
afraid
Tejeda.
I don't understand how preservation has anything to do. I mean, it's not mentioned in any of these cases, although I appreciate your research, indicating in your brief that it wasn't. Maybe that's a way to distinguish these cases, although there's nothing in the case law that suggests it. And of course, if it's not a crime at all, even if you don't raise an objection, there's inherently going to be a substantial risk of a miscarriage of justice. And so Brown himself should have been entitled to the benefit of his own case. And frankly, I guess I can say, in my opinion, Brown's wrong. It's absurd. But that's not for us to say we have to apply it. And I just don't see the difference. I don't see how the objection makes this any stronger a case than Brown's own case.
It does because that was the law at the time of this trial. All the ad hoc prospectivity that comes with Brown is post this trial. And so that was the framework that Mr. Lopez-Ortiz and Mr. Shea was.
I'm sorry.
Yep.
That was the law. You mean the law of prospectivity and retroactivity?
Yes. Yep. And Mr.
So
Shea is.
The Commonwealth says otherwise, right? The Commonwealth says actually not the way the law was up until adjutant came down.
Until which came down, Your Honor?
Adjutant.
Adjutant. I'm sorry.
Adjutant.
Yes.
Sorry.
Yep.
But adjutant decides to apply things retroactively. But before adjutant, that was a break with the law, is what the Commonwealth says. Are they wrong?
Yes, they are. And I've recited that in.
Isn't it more likely that actually there's been sort of, some have applied it retroactively and some have not?
So there is some incoherence in the law, but
Is that incoherence, or aren't there rationales that are given in each instance? There's a rationale given in Brown for why Brown is applied only prospectively,
yes.
right?
Right. And
So that's not arbitrary. There's a rationale. The court thought about it, and they said, well, it might have been tried differently had they known what the law was, so we're only going to apply it prospectively. In adjutant, they said, we're making a change, and we recognize we're making a change, but it's important. In this case, it would have made a difference, so we're going to apply it retroactively. That's not arbitrary.
I think, A, I think it is, but B, this case does not fall within that kind of exception prejudice to the Commonwealth that they recognized in Brown. The Commonwealth always proceeded on the theory that Mr. Lopez-Ortiz was the shooter. They always proceeded on a malice theory.
Can I ask you a couple of quick questions?
Yes.
With your time running short.
Yep.
First, I don't think I fully understand the argument about insufficiency aside from
Yes.
this. So let's say I agreed with you that we have to look at the case in the, however you put it, drawing inferences in favor of the verdict.
Yes.
The verdict on the charges of which he was acquitted was not found beyond a reasonable doubt.
That's right.
Why couldn't the jury have found, even under your theory, he was still fleeing? The thing hadn't ended. He was fleeing. He hadn't even made it to his car at the time of the shooting, and therefore, drawing every inference that we can draw in light of the verdicts in favor of the verdict, he was he's still guilty of this. I don't understand why that's not available under your theory.
So the only way that we get to that is because it's a necessary implication. It's the only rational interpretation of the jury's interpretation of the evidence. The Commonwealth's evidence was that he was the shooter at the top of the stairs. Mr. Lopez-Ortiz testified, I stopped
You're
this.
saying we have to buy all of his testimony. I don't get that. I think we have to maybe buy everything everything that's not, how would I put it, not inconsistent with his testimony. I just don't see, they didn't have to accept everything he said to reach these verdicts.
Right. I read it as a necessary implication because otherwise it's an irrational jury decision. I don't think it is. But even if the evidence is sufficient, the response to the jury instruction about that same question is prejudicial.
Okay, but
Can we just stay on the other point, though?
Sure.
I mean, I think you don't know what the jury did.
Do know.
What you do know is they found that what the Commonwealth was presenting was not proved beyond a reasonable doubt.
Yes.
That's what you know. And you also know that they found him guilty of unarmed robbery. That's a finding, right? So I think, but that's all we know, right? So then it seems to me that a lot of the argument that is presented in your brief, I have the same problem that Justice Rubin has. I don't think you can take from the jury's decision not to find guilt that there is, in fact, a finding to the contrary, that they agreed with the position that the defendant stated in his factual recitation.
I understand Your Honor's
But let me
position.
ask you this. Don't worry about the red light. I'm sorry to say that, but
Don't worry about the red light.
well, you're worried that I'm taking your time, and I hope we won't.
Thank you.
No, it's
I hope that the head of our panel won't find it that way. My question really-
Presiding judge, not really head of the panel.
Presiding judge, and a fine one, may I add. I was struck by the notion that all they found was unarmed robbery, and did that lead to there's a sentence in your brief along those lines, and does that lead to insufficiency of the evidence? But then I read Morin. I mean, what do you do with Morin?
Morin's a real problem for this case. And I think this case is sui generis, and the difference between this case and Morin is that the defendant in Morin left his co-defendant there to continue the robbery. Here, Mr. Lopez-Ortiz testified, and Your Honor rightly points out, it's a question as to whether or not the jury necessarily accepted it. I think that's the only rational implication of the verdict, combined with the juror's notes to the judge asking for leniency. That's how I draw that conclusion. But I know that's post hoc.
Well, no, the difficulty is that the assumption of rationality in the jury verdict is just not, I mean, one of the Supreme Court cases you cited, United States against Powell, talks about that at length. We accept inconsistent jury verdicts. We allow it to happen.
Yes.
Pretty much because of jury lenity.
Yeah, yes, but we only impute irrationality to the jury when it's apparent from the record. Here, everything lines up with Mr. Lopez-Ortiz's testimony. Based on his testimony, this verdict is entirely rational, based on his testimony and the judge's instructions. But I recognize that Morin is trouble, and the only way that I get away from Morin is if the jury accepted his testimony that he stopped the assault, and we do know that it's true, that the victim got away, got outside the house, threw a shovel at 3 of the assailants, came back up the stairs, and the shooter shot him. And Mr. Lopez-Ortiz testified that it was Mr. Okuga, not him. So as to the instructional issue, may I?
I don't have a question about the instruction issue. Do you?
I don't know.
No, I'm sorry. Your time has expired. We've given you
Thank you, Your Honor.
extra time, and we will give you extra time if you need it as well. Thank you very much. Excellent and interesting argument. And we will hear now from Attorney Charles.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. Before I begin, I do just want to extend my thanks to both the Court and opposing counsel for accommodating the last-minute scheduling request. It is much appreciated. I'll turn first to the alleged retroactivity of Brown. Your Honor, Justice Rubin, I think you sort of hit the nail on the head, acknowledging your personal thoughts about whether Brown was correctly decided. Preservation is really not the issue here, and the Commonwealth tried to point that out in its brief. Whether an error is preserved or whether an error is unpreserved sort of jumps the shark in the sense that you first have to find an error. And here, in Brown, the Court was very clear that pre-Brown felony murder law was constitutional. They did not, that's why the concurrence rather than the majority opinion changed the law, because the Court found that the law as it existed, the common law of Massachusetts prior to Brown, as to felony murder, was constitutional. So we were talking about a change prospectively to the common law, which, as the Court recognized in Martin, was a change, not a clarification. So Fiore, Bunkley, Griffith are not applicable here. And I would say, Justice Englander, that I'm not sure the Commonwealth argued that adjutant changed the regime. I think the Commonwealth's position, more accurately, was that it has always been the prerogative of the SJC, when talking about changes to the common law, to determine whether they should or should not be retroactive.
What do you do? So one of the arguments that I arbitrary, because then you're just making it up, is I think what they're saying. What do you say to that? And are they right that what Brown did is inconsistent with the way retroactivity law had been applied up to that point?
So a couple of responses. Specific to Brown, I don't think it was inconsistent. And I would point, Your Honor, there are several cases the Commonwealth cites in its brief, but I would point you specifically to the Castillo case from 2019. There, the SJC made specific substantive changes to the law of common law theory of extreme atrocity and cruelty. The defendant in that case had objected to the instruction given. And in that case, the SJC said, you know what, that instruction is not a fair statement of what the jury should have to find extreme atrocity and cruelty. We're going to substantially alter the instructions and what a jury needs to find as to specific canine factors. Notwithstanding that the defendant objected, the Court did not give him the benefit of the change.
That's
they did what they did in Brown.
But that's 2019. Did you say Castillo's 2019?
Yes.
Brown is 2017. So I think their argument is Brown wasn't following the rules before that predate 2017.
So again, I will say that, first of all, I don't think it's not an arbitrary, they're not making arbitrary decisions, to use your word from when my brother was arguing. There are clear rationales. For example, in Matchett, all the way back to the 1980s, the Court was very clear there that they were addressing a felony that they had never applied the felony murder doctrine to before, extortion. And so we had a situation where there was not a body of case law that had been applied to that particular felony. I would argue that Moran, it was somewhat the same thing. The Court had not consistently applied felony murder in the same way to every single felony that you could commit that had a potential penalty of life.
No, go ahead. In this case,
Yes.
you tried this on the theory of malice as well as felony murder.
Yes.
If the rationale for not applying it to a case articulated in Brown is, look, it could have been tried totally differently, and it wasn't. It was here. So why not apply it?
So my response to that would be that twofold. First, although that was the articulated reason of Chief Justice Gantz in the Brown decision, the ruling was not, the holding was not, you must find that the Commonwealth would have tried the case differently in order to not apply.
They haven't really addressed that question.
Well, I do think they have addressed that question. In Pfeiffer, for example, the defendant both was tried on a malice theory and received an involuntary manslaughter instruction. Both of the things that Chief Justice Gantz had alluded to might have been done differently, and they still did not apply felony murder to him. And this court, and I apologize, I cited the case in my brief, I don't have it in front of me, has affirmed a second-degree felony murder conviction post-Brown, declining to address its retroactivity, even where the defendant was found guilty of only second-degree felony murder.
In a published opinion?
I'm sorry?
In a published opinion?
Yes, there was a published opinion, and I apologize for not
No, you don't
having
have to. We have your brief.
initially. It
so-
is in my brief. There has been both a published and unpublished opinion from this court post-Brown in which they've affirmed its prospectivity and refused to apply it to second-degree felony murder convictions. But I think the Pfeiffer case most astutely addresses your question, because there again, malice was a separate theory alleged and pursued by the Commonwealth, and the defendant in that case received an involuntary manslaughter instruction. The Commonwealth did not request an involuntary manslaughter instruction in this case, which again is something that Chief Justice Gantz recognized in the Brown case might have been something that would have been done differently if we had known that the law had changed. So again, I just want to close the loop, Justice Englander, on your other question. The Supreme Court of the United States certainly has not said at any point that it is a due process violation or an arbitrary and capricious act for a state-level court to apply changes to their common law as they see fit. And
You mean in terms of retroactivity?
in terms of retroactivity, and I cite the
So
great...
that's another way of saying the following. There's no case that says that there's unconstitutionality in what they're arguing.
Well, so I would actually disagree with that. I think it's a tough analogy to make because it's not in the criminal context per se, but I cite that Great Northern Railway case from the early 1900s. Essentially, in that case, a railway commission had
Federal law has nothing to say about it.
I'm sorry?
The case says federal law has nothing to say on the subject.
Correct.
Or words to that effect.
That is functionally what the court said. They said whether the state law wants to apply something, whether a state wants to make a common law change and apply it retroactively or prospectively, the Constitution, the federal Constitution has nothing to say.
What year was that?
I'm sorry?
What year was that?
I believe it was 1932 or 1933.
A few years later, some things changed at the Supreme Court with respect to how they look at what the Constitution does and doesn't do, though.
All I can tell you, Your Honor, is that that is the case that from the United States Supreme Court, it says what it says. They have not since revisited the question. They have not, there is no case the defendant can point to that suggests that they feel any differently about common law as
There's
opposed
also no case in which they've upheld applying a criminal sanction to someone who committed a crime when it was criminal and who, pending appeal, the law changed and it was no longer criminal. There's no case doing that either, right? There's nothing either way.
I would agree with that assessment. I would also point the court to the other case the Commonwealth cited, Rogers versus Tennessee, which is a 2001 case from the United States Supreme Court. Not directly on point, but a post-crime change in the law, right, with respect to the year-and-a-day rule that Tennessee applied that harmed the defendant in the sense that it allowed the Commonwealth or the government to go forward in that case with the murder charge. The defendant argued that the retroactive application of the law in that case prejudiced him, and the court said, that's not our problem. The state chose to apply this retroactively. We don't see an issue with them deciding to apply their law change retroactively. They could have chosen not to, but that was their decision. Now, it was framed more in the context of...
That with respect to sentencing?
It was with respect to could they proceed on the murder charge because the victim died more than a year after the defendant stabbed him, and there was a common law rule in Tennessee that had stated if the victim dies more than a year after.
Procedural, non-substantive rule.
I think that's fair to say.
One would think
And
that
it was
that's
an
probably likely.
Again, I acknowledge that there is no case directly on point. I'm just trying to give Your Honor some evidence that the Supreme Court
Well,
doesn't...
but the problem I was having is, based on cases like Fiore, I would think that if it were a substantive change that post-dates, they're not going to apply it retroactively. They would not allow the state to do so. That's why I was struggling with the hypothetical.
Understood, Your Honor. And I do think Fiore largely is also relevant to the question. You know, unless you find that the SJC erroneously decided that this was a change as opposed to a clarification, which I'm not sure this court has the power to do, and B, I don't think was an incorrect articulation of what happened in Brown by the SJC, then those cases apply.
Can we talk about the peremptory challenge?
Yes, sir.
You've seen the argument of the defendant and also the amicus argument about this.
Your Honor, I have not seen an amicus argument. I was never actually served. I don't believe I was served with a brief. I saw an application to file a brief.
Wow. Oops.
Oh, boy.
Well, we'll have to look and see what happened with that. I mean,
If
that's the obligation of counsel.
If I'm misstating that, I mean, I was on trial, but I don't recall. I saw their
Well,
application
in
to
any
file
event,
a
you
brief.
haven't read the amicus brief.
I have not, Your Honor.
Okay.
Okay. In any, oh, go ahead.
Let's talk about the appearance and demeanor strike, potentially.
So I would
No
dispute that
no
characterization.
Well, no findings are made by the trial judge, correct? About whether that was a bona fide reason, correct?
The trial judge did find that it was an adequate and genuine reason given by the prosecutor. She explicitly found that on the
I'm
record.
talking about the specific, about the demeanor of the juror.
The Commonwealth's position is that the Commonwealth was not striking the juror based on their demeanor. The fact that there was a reference within the larger explanation of why the Commonwealth was striking this juror to him being flippant, I would say, does not make the thrust of the strike demeanor-based. The Commonwealth challenged this juror because he raised his hand to a question asked by the court about whether he had an issue with the fairness of the case. When asked about that question, he gave a response that essentially was,
Well, I remember that, but that was part of the reason. The prosecutor at the trial also mentioned that the juror seemed flippant. Why isn't that a factor that the prosecutor used in striking the juror? You want to put that aside and say the reason was because of the other reason, but this was like a litany. There was a litany
again,
of things.
so two responses. One, as Justice Englander sort of acknowledged in his exchange with my brother, there is no definitive requirement here that the judge have articulated this specific explanation of why she was finding that to be credible.
No, but there's a legal question here about whether it's adequate.
Well, there's a legal
That's not a
question that has
fact.
to be viewed-
I mean, it might be a mixed question of fact and law, but there's a legal question embedded in it, which is, as a matter of law, can X be an adequate reason?
Well, but it is a legal question that has to be assessed with deference to the trial judge who observed what was happening and viewed the exchange.
Legal questions are not entitled to deference.
Not deference in the sense that it's an abuse of discretion situation, but the courts recognize that the trial judge is there and is observing what is happening.
Okay, but so
and the judge made statements on the record about this juror's statements and demeanor.
Yes, the judge concluded that the juror stood fair and impartial.
For purposes of a cause challenge, the judge did, as in Williams, where
No.
the potential juror
For
said...
For all purposes, the judge found this person fair and impartial. That
Yes.
doesn't prohibit someone from exercising a proper peremptory strike.
Correct.
In fact, every time you offer a peremptory strike, the judge has found the person.
I would submit this is not dissimilar from the Williams case. In that case, the potential juror said, I believe the system is rigged against young African-American men. Chief Justice Gantz, in his concurrence, was very clear that had he been the trial judge, he would have probably denied the cause challenge and allowed the Commonwealth to exercise a peremptory. While
That's
there was
cool.
not a cause
How many judges joined that opinion?
I'm sorry?
How many judges joined that concurrence?
I don't believe any other judges joined that concurrence.
Justice
But in that case,
Graziano
again,
did, actually.
the court found that the
Graziano
cause challenge was acceptable in that case.
Well,
So-
but here's my question. I think it's the same as what Judge D'Angelo was getting at. There's a whole bunch of reasons here. So I have the full paragraph that the prosecutor said there. She said, it is based on his answers to the questions that he came in here and stated and indicated his issues that he had with police previously, his beliefs that he feels the defendant cannot get a fair trial. And while he said he could put that aside, the Commonwealth doesn't believe that he's in a position to give the Commonwealth a fair trial based on his beliefs. Again, going back to the questionnaire where he seemed upset or offended in some way about the particular question number 18, do you believe that Dominicans or Puerto Ricans are more likely than members of other ethnic groups to commit crimes. Let's just take that very last piece.
I think that was borne out by the record. The colloquy between
I
the judge
agree,
and the
he
juror
was
bore that out.
upset. The question is whether that's a neutral, non-race-based reason. So I'm Jewish. If I saw a question on a questionnaire, although if I thought, I'm a lawyer also, if I thought about it, I think, oh, the defendants have put this in to try to help make sure there's no one bigoted. But whatever, I don't, you know what I mean? I can't expect a lay juror to say that. If I saw a question that said, do you believe that Jews control all the banks in the world? I would be offended because I'm Jewish. And it seems to me that being offended by this question doesn't really tell us. I'm sure there are, of course, non-Jews who would be offended, but I would think an overwhelming number of Dominicans or Puerto Ricans might be offended. So let's just, if that's race-based, and I understand there are arguments it isn't, but if it is, doesn't that destroy this whole explanation? Because if it has a single race-based factor in there, isn't that a problem? Even if we could say, oh, but his interaction with the Florida police was not.
So trial counsel made the same argument, I believe, to use Irish individuals instead of Jewish individuals. And the trial judge astutely noted there's a difference between being offended by a question and taking the time to write out on the juror questionnaire comments about the question. That is the thing that the prosecutor honed in on, not his offense to the question, the fact that he took the additional step of writing out his displeasure on the jury form, coupled with, first of all, again, I think if you read the proffered answer, the thrust of the proffered answer regarding why this individual was struck is because he raised his hand and said something that the prosecutor, and frankly the judge, who said that he, quote, expressed an attitude initially that the system is not fair, slanted against certain people. That was the thrust of the challenge. And oh, by the way, he had a disgusting experience, not just with police, but also prosecutors in Florida. So that was the thrust of the Commonwealth's challenge. It was kind of a throw-in at the end that, oh, by the way, he made a notation on the form that he found this particular question offensive, a question the defense asked for to weed out potential prejudice in the case. I would also note that 2 prior Hispanic jurors were voir dired. The Commonwealth was content with both of them. Defense counsel peremptoried one, I believe because he maybe looked like the victim was the justification given by the defendant. The Commonwealth had not previously expressed displeasure with any of the Hispanic jurors that had come before the court. There clearly is record evidence here that justifies the peremptory challenge. To say that this was a race-based challenge in the face of the judge's
race-based explanation.
To say it's a race-based explanation in the face of the judge's finding that it's not, I think, is just contrary to there's no indication that this was race-based at all. The Commonwealth explicitly says.
The whole thing's about race. That's the problem with it. That's the problem I have with it, because this is a peremptory challenge. And when you put in questions that are based on race, and people start answering questions that are based on race, and the answers to those questions are a backdrop against which you exercise a peremptory challenge, there's going to be this kind of issue. And I just have real difficulty sort of working my way through this.
May I respond, Your Honor?
Of course.
This was not a colloquy based on a question asked by the court. This was a colloquy that originated with a statement made by the juror after he raised his hand about the fairness of the system.
I think you misunderstand. That I'm not challenging what you said. I'm expressing my view of what happened here. And when you start with a questionnaire that has explicitly race-based questions, and you get explicitly race-based answers, like, I don't think he has enough of his people here. That's an explicitly race-based answer by the juror. It's very hard to separate out what the heck is going on. That's what I'm expressing.
And if a Caucasian juror had stood up and made the exact same statement, the Commonwealth would have immediately peremptoried them, and we wouldn't be here arguing to you that it was an improper
Well, we wouldn't have to worry about
challenge.
it because it was a Caucasian juror.
The point, and to echo what Your Honor expressed during my brother's argument, the Commonwealth is functionally now in a position where no matter what we do, if the juror is not white and the juror is struck struck based on a peremptory challenge, we are going to be accused of racism, and everything we say or don't say is going to be evidence that the Commonwealth acted improperly.
I disagree with that. I don't think that's what this is about at all. Because in this case, it's not, oh, you just struck one, you didn't strike these two and you did strike this one. There's a whole, as Justice Englander says, all anyone has been talking about this juror is their reaction, really, to the question of race, the question of race among the jury veneer, the question of race in the question. It's not like, I have three indifferent jurors and I just pick one and knock them out.
Again, the question about race, the rigging of the system, that is functionally indistinguishable from the comment that was made in Williams, which the court found was a proper basis for a cause challenge. If something is a proper basis for a cause challenge, it has to be a competent reason for a peremptory challenge. So we have that initial statement, which is not the same statement, but functionally indistinguishable from, I think the system is rigged against young African-American men. We also have explicit mention by the prosecutor, first and foremost, about the disgusting incident with police. And I take offense to my brother's suggestion that just because someone's had a positive experience with police, the Commonwealth is required to ignore that. Defense attorneys peremptory every single juror that says police are more likely to be truthful than other witnesses, or that they have law enforcement in their family, or have had positive experiences with law enforcement. So to suggest that the Commonwealth can't peremptory people who suggest that they've had a disgusting experience with both police and prosecutors.
Counsel, can I ask you a hypothetical? Because I have problems, frankly, with the last part of what the prosecutor said, which I alluded to at the beginning, the comment about flippant and the comment about the attitude. Let's say that there is a peremptory challenge made, and it goes to the prosecutor, and the prosecutor lists 5 legitimate reasons from the questionnaire about why the juror should be excused for a peremptory. But his last, number 6, is, and he's black, I don't like black people. Even though 5 reasons are legitimate, the 6th one is not. And the judge says, thank you, Commonwealth. To the extent it's necessary, I find that the Commonwealth, for the same reasons identified, exercised rationally a peremptory that's adequate and genuine. Would that be okay because the first 5 reasons are legitimate?
No, it would not be okay. But again, I don't think that's what happened here. The Commonwealth was objecting. As the judge pointed out earlier in the colloquy, it was the fact that this juror took the extra step of writing something on, in the same way that he raised his hand initially and expressed concerns about the fairness of the process. He took extra steps to express displeasure with a question that was specifically requested by the defense to weed out potential prejudice in the jurors. It was again, I don't want to call it demeanor because the focus of the thrust of the challenge.
See, that's where you're losing me. I don't know what the thrust of the challenge is. There was a litany of reasons given by the Commonwealth, almost as if it was 1, 2, 3, 4. And number 5 and 6 are about flippant. He answers sure flippantly. And number 6 is his attitude coming into this trial. That could be said about every potential juror in every trial. The Commonwealth could say, I didn't like the attitude when he walked up here to answer your question. I want to exercise a peremptory. And the judge didn't make any finding. A finding, perhaps what Justice Englander was alluding to earlier, if he said, yeah, I did see the juror come up and he was being a wise guy. Okay, now we have a legitimate thing on the record. That wasn't done here. The judge just said, I accept everything.
Again, Your Honor, while I will agree that in an ideal scenario, the judge would have made further finding, here we have to look at it based on the entirety of the colloquy. The judge did not even feel as though there was the necessity of providing an explanation by the, I apologize, I should have asked if Your Honors would entertain the answer.
You can finish answering, but we are well beyond time, although that's fine.
The judge was not inclined to even require an explanation from the Commonwealth because she felt that it was a close call as to the cause challenge and that there were clearly justifiable reasons for the Commonwealth to want to peremptory this juror. She indulged the defendant after repeated additional requests by counsel for a reason, not having even found that step 1 was satisfied. And whether you want to call it a pattern, there is an inference that has to be rebutted at the first step. And the judge's view was that has not been done here. She humored the defendant and asked the Commonwealth to give an answer The Commonwealth gave an answer that in the Commonwealth's estimation was not race-based, was not contingent on the race of the juror. It was contingent on what he said to the attorneys and the judge throughout the colloquy and the opinions that he expressed.
Okay,
and that was adequate and genuine.
I think we understand your argument, although if there are further questions, I will. Thank you very much. We've kept you longer than we should. Very helpful argument from both of you. Very interesting case. And it is submitted. As that is our only case for today, I'd like to thank the court staff and particularly the court officer for their assistance today, as always, and we stand in recess.
Well argued.
All right, please.